Hello, everybody, and welcome back to the Jurisprudence podcast with me, Alex.
And me, Charlotte.
And today we're going to be talking quite a lot about one of arguably the most groundbreaking cases that we've seen in quite a long time, actually, in the International Court of Justice. So we're concerning ourselves with international law today, and generally speaking, I've taken the lead on this.
Yeah.
And we said that in the last episode that one of the things that we essentially are going to do is that every 2 weeks or so, or every time we have a podcast idea, one of us is going to do the groundworks and provide some of the details and write the Substack article, and then the other person is just going to engage with it in the podcast itself. So been my it's been my job this week to essentially talk about the advisory opinion, to write the article about the advisory opinion, and you are going to be asking me questions about it as we go along. Basically, is that?
Yeah, you've basically taken the reins on this, and I've sort of familiarized myself with what we're actually going to be talking about. So I have a rough idea of what questions I want to ask. But generally speaking, I'm not an international lawyer by any means.
No.
So this is very much Alex's remit, and I'm basically going to be the role of the audience in this instance.
Yeah.
And just trying to unpick the kinds of things that you want to talk about.
Yeah. And given that this is an advisory opinion ruling on the legality of occupied Palestinian territory, and so we're concerning ourselves with the Israeli-Palestinian conflict, starting out the first proper episode of the podcast with the least controversial of topics, if you will.
You couldn't have picked a less controversial topic.
No, I don't think so either. This is a really easy topic.
Yeah.
And fundamentally as well, this is a topic that you, in some cases, pride yourself on staying out of in terms of discussions and not getting involved. Not really interesting yourself in it. You're a domestic lawyer.
Yeah.
You're a domestic criminal law scholar.
Yeah.
Your international law is not where you're going, basically.
Yeah. Well, I've had plenty of stuff in the news recently in England and Wales to be getting my teeth into.
Exactly.
The protests that we talked about last week. But yes, as far as this conflict is concerned, I've been living under a rock insofar as Alex allows me to.
Yeah, fundamentally, yes. So let's get into it then. Let's start talking about this opinion. Now, I mentioned that this is probably one of the most groundbreaking advisory opinions, potentially one of the most groundbreaking opinions in the International Court of Justice more generally. And I've written a very, very long article discussing only some of the points. And I want to make a note here that there are some points that we're not going to talk about here because they are touched on in the advisory opinion, but they probably merit their own set of podcast episodes, really. So, for example, the question of Palestinian self-determination, whether or not Palestine is a state, what the implications are for occupation of Palestine as a state, what impact this has on the International Criminal Court's arrest warrants, the pre-trial chamber, all of that stuff, we're going to save for a different episode. So just take that out of your mind straight away. And really, it's only briefly touched upon in the judgment anyway. What we will find is that the court, in order to essentially try and ensure a maximum amount of unanimity as possible, has deliberately, in my opinion, steered away from some of the really controversial decisions, which hampers some of the legal analysis to an extent, but it still nevertheless doesn't take away from how significant this judgment fundamentally is. You want to say anything?
Yeah, I think in the first instance, while Palestinian sovereignty does come into it in a sense, because you do mention it in the Substack article,
yeah.
But they really don't want to get into the nitty-gritty of it, and neither do we, because this could be an hour talking about that, and that's why you say this is for future episodes potentially.
Yeah, exactly.
Because there's a lot of contextual issues that have led to the framing of this advisory opinion. I'm assuming you agree with that.
Yeah,
that's
100%.
why you started off with talking about October the 7th and the
the events,
political context of what has been taking place.
Yeah, so I think that's a good place to start with just some basic preliminaries. So before talking about the advisory opinion, the detail of the advisory opinion itself, I want to just quickly make a point that this was an advisory opinion which began life before the October the 7th, 2023 attacks by Hamas on Israel and all of the subsequent Gaza war and all of these other things that have taken place. Now, while there are definitely cases in the ICJ concerning events that have taken place after that, so for example, the Nicaragua-Germany case, and obviously most pertinently the South Africa-Israel case on the Convention on the Prevention and Punishment of the Crime of Genocide, this case concerns itself with questions that were lingering and continue to be lingering since prior to October the 7th and have been lingering for many, many years, maybe even decades.
Particularly about the West Bank, right? This is what we're talking about, because that's been an ongoing issue prior to what happened on October the 7th and is separate in kind of context to what is happening in Gaza right now, even though it's to do with the broader conflict.
Yeah, it's all intertwined to an extent, but it is definitely a separate issue. So the advisory opinion itself is, of course, an advisory opinion looking into the legal implications of the ongoing occupation in the West Bank or in occupied Palestinian territories. In fact, we talk about Gaza later on. And I just want to begin by making a point of what I mean by an advisory opinion, for those of you who do not know. Well, fundamentally, the International Court of Justice is the highest judicial authority in international law. Fundamentally, it is the principal judicial organ of the United Nations. And it exists to have two types of jurisdiction. It has firstly contentious jurisdiction, which is where there are states involved in litigation against each other. So, for example, if there is a maritime delimitation case or there is a dispute about a particular implementation of treaty law, then a state can sue a different state. And this is the case when we look at, for example, the South Africa genocide case. That's a case that has contentious jurisdiction because it's South Africa directly alleging that Israel has violated her obligations under the Genocide Convention.
Yeah.
And then on the other hand, the counter to this is the advisory jurisdiction, which is essentially where an organ of the United Nations, often the General Assembly, is able to ask a question to the ICJ about a particular legal problem. And the ICJ will have hearings, will have oral proceedings, will have back and forths, and then they will deliver a judgment on what they believe is the correct legal interpretation of that question and answering that question. And the importance of this distinction is simply that contentious cases are legally binding onto the parties, whereas advisory opinions are not, because there aren't any parties per se.
Yeah. So, my first question to you is, with an advisory opinion, is it typical for it to exist within the context of an ongoing conflict, such that it is sort of in lieu of a litigation between states?
Well, generally speaking, this has been a matter of contention in this case, with a couple of scholars, a couple of commentators taking issue with the fact that what they believe to be the case that is happening right now is that, well, this is just basically a dispute between parties. It's a dispute between Israel and Palestine, but because Israel have refused jurisdiction, have refused consent to actually can submit themselves to the court, this essentially means that that the General Assembly has found a sort of backdoor route to talk about a dispute between parties in a way that doesn't require the consent of Israel, and that this is therefore a violation of their sovereignty. This is fundamentally a basic contradiction in terms of the basic principles that have been set out by the court previously. So the court has, for example, been very much in the business of allowing itself to get involved in these disputes, and it seems to be on the basis of the fact that these opinions are not binding. These are non-binding opinions. These are not opinions that are binding onto states. These are opinions which essentially answer questions that are set to the ICJ by an organ of the United Nations. So, for example, in terms of cases that have been cited, I would refer back to the 2004 construction of a wall advisory opinion, which was an advisory opinion concerning very similar factual circumstances that we have here. This was about the construction of a wall in and around around the West Bank and the occupied Palestinian territory. And it discussed the legality of Palestinian territory. It discussed the illegality of the occupation to a lesser extent, whether or not violations of international law have been taking place, and all these different kinds of things. So the context in which this is actually issued is the fact that essentially the previous jurisdiction, the previous jurisprudence made the point that it is completely within the court's remit to be able to deal with disputes, what seem to be disputes in an advisory setting, if that makes sense. And I discussed this in the article itself. I talk about the question of whether or not this is essentially just a dispute between parties that's being sort of hidden and being hidden by the fact that it's an advisory opinion.
Because at the end of the day, the purpose of this is to answer a legal question about how we understand occupation.
The legality of this specific occupation, yes.
Right, okay, yeah. So you say that you don't ascribe to the view that this is kind of a backdoor way of forcing Israel's hand.
No, it's not.
But would you say that it provides scope to do so based on what answer is provided by the ICJ?
Well, in the sense that even though an advisory opinion isn't necessarily binding, is non-binding onto states, it can still have authority in the sense that it has quite a lot of persuasive authority, and it can force third-party states to act in terms of their relationship with Israel and in terms of the General Assembly's resolutions. But all of this is perfectly reasonable and within the remit of the court's jurisdiction anyway. The court distinguishes between contentious cases and between advisory cases. It said in the war case, for example, quote, "The fact that in the course of its reasoning and in order to answer questions submitted to it, the court may have to pronounce the legal issues upon which divergent views have been expressed by Palestine and Israel does not convert the present case into a bilateral dispute." So just because it has to deal with things that might be considered to exist under the remit of a dispute in a contentious case doesn't mean that it converts the entire case into a bilateral dispute. And so therefore it is not a covert way of trying to essentially undermine Israeli sovereignty through the back door, essentially.
Yeah. So in other words, just because their finding in the advisory opinion might fall on the line of vindicating Palestinian grievances in terms of the legality of the occupation doesn't necessarily mean that they're imposing something on Israel.
No.
It's just opening scope for further kind of litigation down the line.
Theoretically, yeah. I mean, they're not imposing any legal obligations onto Israel, but in doing so, there's obviously the political realities and the geopolitical realities of such an advisory opinion. I want to just very quickly then sort of take a step back and talk very briefly about the history of this particular region.
Yeah.
So fundamentally, this is a case which concerns occupied Palestinian territories. Now, occupied Palestinian territories generally refers to the West Bank. It refers to a lesser extent, but still in a complicated manner to policies that take place in East Jerusalem, and it also concerns the Gaza Strip. Now, essentially, these are areas of territory that have been occupied since 1948. So they were occupied in 1948 in terms of the West Bank by Jordan, and in terms of the Gaza Strip by Egypt. And so this is really where it stayed, and it sort of post-conflict in 1948 when Israel was established and when there was the first Arab-Israeli war. This essentially solidified the border lines that existed. And I make a mention of the point that basically there are 3 or 4 different pieces of territory that we talk about when we look at the Israeli-Palestinian conflict. We talk about Gaza, we talk about the West Bank, we talk about East Jerusalem, and then we talk about Israel, quote, inside the Green Line, which is just sort of Israel proper, which is just the sort of bit of land that the piece of territory that existed at the end of the 1948 war, the sort of the ceasefire lines.
Yeah.
So that's what happened in 1948, and then from 1948 onwards, for a few years, things sort of stayed roughly static in that regard. And then in 1967, we have the 6-Day War. I'm not going to litigate the 6-Day War in any great detail, but ultimately it was a conflict that Israel won, and they won back a lot of this territory. They took the West Bank, they took the Gaza Strip. Okay. And since 1967, this has been the state of play. It has been occupied Palestinian territory in the West Bank and inside the Gaza Strip. And so from there are a number of implications that need to be spoken about, that we're going to speak about as we go into looking at all the various different parts of this judgment. For one, you have the fact that despite the fact that they had occupied Gaza since 1967, they had Israel that is, unilaterally disengaged from the Gaza Strip in 2004-2005. They tore down the settlements and they left the Gaza Strip. And so there's the question of whether or not Gaza is still an occupied territory under the basic definition in international law. That's something that the court sort of deals with, but doesn't come to a clear and delineated conclusion on that one. And then there's the question of the annexation of territory, because basically ever since 1967, Israel have been encroaching on Palestinian territory in the West Bank by constructing settlements. And the question of legality of the settlements and the question of what this has as an implication for the occupation is something that the court talks about.
And that's
the history.
Thank you for that.
Yeah.
That's sort of what I was alluding to earlier when I said that, from what I understand, there are different circumstances in both Gaza and West Bank.
Yeah, it is different, and there are definitely now post October the 7th, because of course now you have the fact that there's been a war in Gaza that's been taking place over the last 10 months, and there is a quite substantive Israeli presence in the Gaza Strip again. So that's also something that needs to be spoken about. Do you want to just go through the sort of preliminary questions, the idea, the charge that it's a political judgment and that kind of stuff?
Yes.
And the lacking of a factual basis as well was one that's interesting.
Yeah, I think those were the sort of main points of misunderstanding that you wanted to address before we got into the substance of it. That it sort of what we were speaking about earlier in terms of, is this forcing Israel's hand? Is this a political weaponization of the court's jurisdiction against Israel?
Yeah.
And I said in my notes after I read your post that you addressed this quite succinctly in the post.
Yeah. Well, fundamentally, there are people, admittedly not legal commentators, suggesting that this is a weaponization, that the judges have become politicians and that they have been able to just make a political ruling on political matters and all this kind of stuff. Now, every single person that seems to do that either misinterprets the history or doesn't engage in the judgment itself, doesn't engage in any of the legal facts of the judgment itself. And I would probably just come to the conclusion that, according to Malcolm Shaw, quote, the fact that a legal question also has political aspects will not deprive the court of its jurisdiction nor its function, which is to assess the legality of the possible conduct of states with regard to obligations imposed by them upon them by international law. So even if there is political aspects of it, it doesn't actually strip away any jurisdiction of the court itself.
And I think ascribing that sort of motive to the court
Mm-hmm.
is missing the purpose of this sort of exercise. That's what I put as well, that people who aren't legal scholars don't really understand the point of answering a legal question.
Yeah.
um you might then, after that legal elucidation, sort of come to political conclusions,
Mm-hmm.
but the purpose of the judgment itself isn't supposed to be political.
No. And it fundamentally isn't political. And I guess the second grievance that a number of people made was that the court lacked a factual basis to make a judgment. So the idea here is that they didn't have accurate, reliable information on the question, which didn't allow them to make a conclusive judgment on the basis of the facts itself. This is actually something that Judge Nolte, who one of the judges in the ICJ, makes the point as well. They make reference to this idea of it being a bird's eye view of the situation, and this has implications for the scope of the court's conclusions. In addition, Judge Cleveland argues that it was essentially disappointing that Israel didn't participate in this judgment, and really in response to the claims that it wasn't made on the basis of a factual analysis. I would probably just refer to what Marko Milanovic said when speaking about this on the IJIL podcast, which is that Israel had the choice to engage in the proceeding. They had allotted to it a number of hours for oral argumentation. They had the ability to present what Israel would perceive to be a quote more factually accurate or more balanced interpretation of the facts, but they chose not to. So they can't moan about the fact that it wasn't done, that the judgment isn't made on the basis of a factual analysis if they have refused to actually provide anything of a factual analysis. So as far as I'm concerned, it doesn't matter whether or not they lacked a factual basis in the judgment. It might still undermine some of the points of the case, but fundamentally that's the only person that can be the only state, shall I say, that can be blamed for this is Israel themselves.
Yeah. I recall I said something to the effect of, if you have something that you wish to use in evidence to support your defense, not submitting that is your own fault, basically.
Exactly.
Coming from a criminal lawyer.
Yeah, exactly. Well, yeah, exactly. So in a situation where there's an advisory opinion that they want to respond to, they had the full rights to do so, and they had the full rights to make a case for a more balanced, in their view, more balanced interpretation of the facts, but that they chose not to. So the court can only do a judgment on the basis of what is presented to them. As Cleveland says herself, the failure of a state to participate cannot prevent the court from fulfilling its responsibilities in replying to an advisory request, which is, yeah.
Yeah, they basically will provide an answer on the basis of what they have access to.
Exactly.
And I think it's also important to note that this is quite a large problem in international law generally, that the collation of evidence is very poor. It's hard to, in situations of conflict, to get a full grasp of the factual basis because of, information gathering issues and that sort of thing.
Yeah, if you make an analogy, for example, between a domestic crime and an international crime, even though we're not talking about international criminal law, we're talking about states and the ICJ. But if we were just to quickly diverge to the ICC for a second, it's very, very. If you were to talk about, for example, the crime of murder in a domestic setting, it's often quite a trivial task in terms of evidence collecting in comparison to ICL, because in a domestic setting you've got a murder scene, all of this.
You've got police officers that can collect the evidence.
Exactly, you have state control. But in ICL, it might be in the case of an occupation. It might be in the case where you're talking about massacres on a scale of hundreds, potentially even thousands of individuals. You've got the fact that in some of these cases, at least, states are involved in actively covering these
Yes.
situations and these atrocities up. So the idea of evidence collecting and actually the workings of international criminal law is just it's a whole different beast to a basic domestic case, which is why they take so long.
And I think that idea of states potentially being complicit in the obscurity of evidence as well is quite important in conflicts and everything, because what was my point?
It's the state being involved.
Yeah. If I backtrack a little bit, when I said about the state of evidence in international law, it cannot be that we rely on a certain standard of evidence in order to make any legal rulings, because then we wouldn't make any kind of headway on questions like this.
Exactly.
That's what my point was.
Yeah, fundamentally, exactly.
Yeah.
Should we get into the judgment itself then?
Yes, please.
So fundamentally, there's been a few individuals, there's been a few articles trying to present the opinion that the court isn't actually speaking and stating international law, partially because of the divergence of opinion among the judges. I would disagree with this. I would say that while there is divergence of opinion among judges, there is a relatively strong and high degree of unanimity on most of the most important points, the main points. And where there is divergence, I'll talk about that as time goes on throughout the rest of this episode. So the sort of main holding of the case, the main point, the ratio of the case, if we were talking from an English perspective, is that of the illegality of occupation, the continued presence of Israel in the occupied Palestinian territory is illegal, and as such, Israel must bring this continued occupation to an end. The language that was used is as rapidly as possible. Now, there's a slight divergence between as rapidly as possible and what Palestine actually wanted in terms of what they wanted, the language they wanted the court to use. So Palestine requested that the language be used is, quote, immediate, full, and unconditional withdrawal. The court didn't go for this and said instead as rapidly as possible.
So the difference there being
just I guess the Palestinian state wanted a stronger ruling, a stronger interpretation of the language. But
I think you can sort of infer there's like a reasonable period of time that withdrawal can happen.
Well, yeah,
so it's like a reasonable response clause.
Exactly, and some of the judges actually do speak about that and speak about Israel's security concerns and all of these things. It would be nice if Israel actually went to the court itself and spoke about them, spoke about those security concerns themselves. We'll get to that in a second. And so fundamentally, the conclusion that they made, the conclusion that they came to, was that the occupation as such is a continually wrongful act within the broader context of international law and state responsibility, and so it has to come to an end. But where there is the first sort of set of divergences, at least in terms of this point, is in relation to the grounding for why this is the case. So firstly, they make the point, which is, I think, a really important point that they make, that the length of the occupation, the fact that it's been an occupation since 1967, actually doesn't make any difference to the extent of or the legality of that occupation itself. The fact that it's taken place for a long period of time doesn't actually make a difference as to whether or not it's legal or not. There's a time period.
Yeah.
So it could theoretically last 100 years of occupation. That doesn't necessarily make it illegal. What were you going to say?
I was waiting to see where you would take this, but I think maybe for the audience, a little bit about what an occupation actually is.
Okay, yeah. Well, so belligerent occupation is a sort of state of play, a state of a thing, or at least a situation, shall I say, that takes place within the context of international armed conflict, in which one state in this conflict takes over and occupies a certain amount of territory of a different state. Okay, and according to Article 42 of the Hague Regulations, territory is considered occupied when it is actually placed under the authority of a hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. Now, the purpose and the meaning of occupation law is essentially, if we were to look at the law of occupation through the lens of the laws of war, international humanitarian law, all international humanitarian law does is define when an occupation exists, and as such, if they have defined that there has been an occupation, what are the obligations on the parties now that the decision that an occupation exists has been identified.
So proper conduct within the occupation.
Exactly. The question of whether or not the occupation in and of itself is lawful or unlawful is a question which falls outside of the scope of international humanitarian law. Sassuli writes, quote, "As with every other rule or concept in international humanitarian law, the jus ad bellum considerations, so the considerations about the international law on the use of force, such as whether or not an occupation is lawful or unlawful, are irrelevant to determining whether a territory is occupied." So the court also makes that clear, that when they say that the occupation is illegal, they are not saying that the occupation is illegal under the remit or through the lens of international humanitarian law, because that doesn't make sense. Because international humanitarian law doesn't deal with legal or illegal occupations. They just deal with whether or not there is an occupation. If so, what are the obligations for parties?
Yes.
Just like international humanitarian law doesn't deal with whether or not an armed conflict is legal or illegal.
Yeah.
That's the UN Charter, that's the jus ad bellum. But as soon as they're identified that an armed conflict is taking place, what about the conduct inside the armed conflict? What about war crimes? What about protection of POWs? What about targeting decisions, etc., etc., etc.?
So you made a good point that you can have illegal conduct within a legal war, as in there was just cause for war, but once you're doing that war, you are conducting yourself illegally.
Exactly.
Whereas you can also have
an
legal conduct within an illegal war.
Yes, exactly. So these two things are fundamentally different areas of law.
Yeah.
So then the question becomes then, if international humanitarian law isn't the grounding from which this decision is made, the grounding from which the legality of the occupation is made, then under what determination is it made by the court that the occupation is a continually wrongful act in international law?
Yeah.
And this is really where this is one of the things that Milanovic takes issue with one of his posts on this question, because essentially all of the points that you could be referring to, and all of the suggestions for why this occupation is illegal, aren't really dealt with in any meaningful sense by the court in this judgment. So, for example, you could make the case that through the annexation of territory, through the expansion of settlements in the West Bank, this essentially represents a violation of the basic principle of international law, which is the illegality or the inadmissibility of territory acquired in conflict. And from that perspective, it renders the occupation unlawful.
Right.
Or, as Milanovic mentions, you could make the point that even though Israel are making the claim that they are acting in self-defense, because they are expanding territories, or because they are expanding settlements in the occupied territory, it's sort of essentially suggesting that the claim of self-defense is pretextual, and that these are just a sort of a front for territorial acquisition, which is obviously unlawful.
So the underlying motive.
Exactly. And if you were to ask Israeli lawyers, they would probably come to the conclusion that Israel have security concerns in the West Bank. They're people who want to see Israel destroyed, just like in Gaza Strip as well, and that these security concerns render the occupation lawful for the sense that they are protecting Israeli sovereignty and that they are acting in self-defense. And it would have been nice for the court to have engaged with that question and to engage with that point, and then ultimately come to a conclusion that it probably doesn't justify occupation in the legality of occupation in the jus ad bellum. But again, the court doesn't really make much point of that. And you can understand why the court doesn't make a point of that, because it's very clear that what the court is trying to do is maintain unanimity as much as possible in terms of these questions, because it makes no sense, and it's not really a useful thing to conclude if you attack all of these questions head on and directly, and then you end up with half the judges dissenting and breaking away and having their own declarations and stuff. That doesn't really answer the legality question to the General Assembly. No. You want to actually present a clear question that actually answers the question. So a certain degree of unanimity is necessary for these kinds of cases.
So basically, it speaks to the original purpose of the advisory opinion, that is to give a definitive answer.
Yeah, or at least insofar as they possibly can.
And then if you're bringing in all of the weeds, shall we say, then, like you said, if we have 14 out of 15. Said the other day.
I think so. Yeah, it was. There was one dissent from the main holding.
Yeah.
But yeah, it was a relatively strong amount of unanimity, even if there were caveats attached to some of the judgments. In terms of the main holding of the judgment, the illegality of the occupation and the requirement of withdrawal as rapidly as possible, this is almost unanimous in terms of the ruling, which is why it's so significant, by the way, or one of the reasons why it's so significant.
Which is great, really, because then using that, you can move forward and start to pick apart these other questions that are sort of ancillary to the question of the occupation itself.
Mm-hmm.
So, like Palestinian sovereignty, like Israeli self-defense, and start to ask other legal questions that can be pinned to this central question of whether the occupation is legal or not.
Exactly. And this is what the court then goes on to do, because the 2 points that I think we could probably finish on are the 2 points relating to, firstly, the question of Gaza, the Gaza Strip, whether or not that's an occupied territory for the purposes of the court, and then also the question of racial segregation and apartheid, violations of the Convention on the Elimination of All Forms of Racial Discrimination, which are, for some people, that latter one is probably the most important holding of the case, or one of the most important rulings of the case, because obviously the question of apartheid in the Israeli-Palestinian conflict is one that is often very much wielded as the sort of main point of criticism of Israel, that they're an apartheid state, that this, that, and the other.
Mm-hmm.
So that is a potential point that we'll talk about after we've discussed Gaza. So essentially, the problem with the question of Gaza, and the reason why this gives rise to such a disparity in legal interpretation, is because while Gaza has been occupied, or was occupied since 1967 by Israel, occupied since 1948 by Egypt, and then by 1967 by Israel, in 2004-2005, there was a disengagement plan in which Ariel Sharon, the Prime Minister of Israel at the time, unilaterally withdrew from the Gaza Strip, tore down all the settlements. This might sound like a quite a loving and a sort of heartfelt approach to the Palestinians, but
sort of like holding up their hands and saying, "Oh, we."
Yeah, but it wasn't. It was more so. It was more because they wanted territory in the West Bank.
Yeah, so they were turning their attention away.
Yes.
Yeah.
Yes. Yeah. Sharon was not a prime minister who was particularly engaged with the reconciliation of Israeli and Palestinian rights, compared to that of people like Barak, for example, in the early 2000s. Anyway, so the question here is then, well, what approach to occupation do we actually think about? And the sort of traditionalist, as I would say, interpretation of occupation is that of a binary approach. Either there is an occupation or there isn't. If there is an occupation, then these things has to be satisfied to make that conclusion.
Yeah.
And one of those things that have to be satisfied, which makes Gaza quite tricky, at least prior to October the 7th, is this idea of boots on the ground. Okay, the boots on the ground requirement is a very difficult one to reconcile when it comes to the definition of occupation with relation to Gaza. Again, I will refer back to the Article 42, the Hague Regulations, where it says territory is considered occupied when it is actually placed under the authority of the hostile army. The implication there, and by extension, is that there has to be actual soldiers on the ground in that territory for there to be an occupation.
Active military presence.
An active military presence, exactly. Which upon that, if your entire definition of occupation hinges on that point, then you would say that between 2005 and 2023, that period of time, Gaza was not occupied. It was not an occupied Palestinian territory.
Which has been sort of raised as problematic for reasons that you're about to say.
Yeah, the reason why this is problematic is because while they didn't necessarily have boots on the ground, there weren't actually IDF soldiers there prior to October the 7th, there was still the fact that Israel controlled the land, sea, and air borders. They restricted the movement of people, the movement of goods. They would collect import and export taxes. They had military control over buffer zones. They had military control over the crossings between Gaza and Israel and between Gaza and Egypt. So the second approach, which I believe is an approach which is presented by the Red Cross and some other scholars, is more of a what is described in the literature as the sort of functional approach to occupation, suggesting that while there may not be boots on the ground, the fact that there are still what some people argue as residual control suggests that there would therefore be residual obligations. So they had occupied the Gaza Strip, and then in leaving the Gaza Strip, they still retain control over a number of different things, like the air, sea, borders, restriction on free movement of people, and all this kind of stuff. And so with the fact that they had that residual control means that they still maintain some obligations in international humanitarian law as an occupation. And that's basically what the court concludes. But again, notice, I'm going to read the paragraph that they make this point, but again, notice the fact that they don't really say that Gaza is occupied. Notice that they will. I'll explain what they do say in a second. But notice that they use quite a nice tricky bit of language to basically try and maneuver themselves through this controversial minefield of maintaining unanimity among the court, but also actually saying something of substance, and saying something that is important for the General Assembly to then actually do something with.
It's actually quite clever the way that they do this, because it can be reasonably inferred that they are encouraging this holistic approach to the definition of an occupation in this sort of de facto circumstantial occupation rather than the traditional active military presence that you described before. Go ahead.
Marco makes the point that this is like sort of legal argumentation as a form of art. That it's like it's less textual and less sort of like legally realist, but sort of quite artistic in terms of its interpretation. So paragraph 93 says, quote, based on the information before it, the court considers that Israel remains capable of exercising and continuing to exercise certain key elements of authority over the Gaza Strip, including control of land, sea, and air borders, restriction on movement of people and goods, collection of import and export taxes, and military control over the buffer zone. Despite withdrawal of its military presence in 2005, this is even more so since October the 7th, 2023. And so from that, they make the conclusion that there are still obligations in occupation that Israel must maintain. So they don't go as far to suggest that it is an occupation. This is they occupy the Gaza Strip. This is occupation, but they just say the sort of the softer point, which is they have obligations in the law of occupation, suggesting firstly that they go for a more functional approach, suggesting that there is a residual obligations in terms of the Gaza Strip, but then they also give the boots on the ground interpretation a little bit less weight than, for example, the European Convention on Human Rights, the European Court on Human Rights, which, yeah, go on.
I was gonna say they essentially say if it looks and smells like an occupation, then have the duty to treat what you're doing as an occupation.
Yes, and then the problem that we come back to there is that only one judge, this being Judge Cleveland, actually discusses what these obligations are. So the court makes it clear that there are obligations that the Israeli state have in relation to the Gaza Strip, but they don't go so far as to name what these obligations are. Judge Cleveland does a bit of discussion about this, but it would be nice if the court had done that as well. Again, probably trying to maintain unanimity among the court so as to not basically wind people up and to cause a complete fragmentation and divergence of opinions across the entire 15 panel.
Because there's no point in attempting at this point to say what those obligations are if no one's going to agree on them, because then at the end of the day, they won't be followed or implemented.
No. And that brings us to the final of the points, which is the question on racial segregation and apartheid. So, from a sort of factual basis, that the policies of racial separation between Israelis and Palestinians, or between Jews and Arabs in East Jerusalem and in the West Bank, clearly shows that there are violations of some basic treaty law on racial discrimination. And the court agrees. The court agrees that fundamentally what Israel have done is violated Article 3 of the International Convention on the Elimination of All Forms of Racial Discrimination. Now, the problem with that is that Article 3 says the following. It says, quote, states parties particularly condemn racial segregation and apartheid and undertake to prevent, prohibit, and eradicate all practices of this nature in territories under their jurisdiction. Now, what has been the sort of the bread and butter of a lot of human rights organizations and a lot of pro-Palestinian activists for many years is getting Israel on apartheid charges. Getting apartheid as being the thing that they are doing, essentially, especially in the West Bank and in East Jerusalem. But the court doesn't particularly help anybody here, because when you read Article 3, okay, it says condemn racial segregation and apartheid. So the actual question is, do they say that Israel is violating Article 3 because of the basis that they are committing racial segregation, or are they committing apartheid, or both? Mm-hmm. Okay, and it seems to be the case on account of the sort of scholarship on this particular provision, which I've cited some scholarship on the article, which we won't get into here, that we do treat the question of racial segregation and apartheid as two distinct things, that you could do one without the other, or you could do both. And this is even seen in the judgment itself. In paragraph 224, the advisory opinion says, quote, a number of participants have argued Israel's policies and practices in occupied Palestinian territory amount to segregation or apartheid in breach of Article 3 of the Convention on the Elimination of Racial Discrimination. So there is this disjunction here. There is segregation or apartheid, okay? And so when they say that there has been a violation of Article 3, they are not telling us whether or not this is a violation on account of racial segregation, or a violation on account of apartheid, or a violation on account of both.
I wonder if it's also worth mentioning that the Article 3 says there's an obligation to, could you go back to so I can read it, undertake to prevent, prohibit, and eradicate. And you could also make the point that if you're simply sort of allowing these circumstances to continue, or having a very lackadaisical approach to the idea of separateness within your state, and sort of institutional segregation and that sort of thing. Not necessarily having a systematic approach to racial segregation, then it becomes a little bit more difficult to pin distinctly this idea that it's a motive, it's an ulterior kind of goal of Israel to commit apartheid.
Exactly, and this is the problem. Now, while Judge Nolte makes the point that quote, the court considers Israel's legislation and measures constitute a breach of Article 3, while leaving open the question whether it considers Israel's policies and practices to be a form of racial discrimination or apartheid. At the same time, you do have judges suggesting that this does amount to apartheid. So President Salam, for example, says, quote, Israel's commission of inhumane acts against the Palestinians as part of an institutionalized regime of systematic oppression and domination, and its intention to maintain that regime, are undeniably the expression of a policy that is tantamount to apartheid.
Yeah.
So the problem there is, if we're being really legally finicky, shall we say, even President Salam doesn't say that they are violating the convention by committing apartheid. They're saying that they have instigated a policy which is an expression that is tantamount to apartheid.
Yeah.
And so you have that problem as well. Fundamentally, though, that even though this is an interesting debate to be had, an interesting discussion for lawyers to essentially go back and forth on, at a minimum, they have found that the policies violate Article 3 by way of racial segregation.
Yeah. So at this point, we're sort of splitting hairs, and the important part is that they found a violation of Article 3
Exactly.
that then they can move forward.
Exactly, and so a finding of Article 3, racial segregation is probably bad enough as it is, without needing necessarily to fixate our attention on apartheid. But people like to have the word apartheid because, of course, that's language that is very, very powerful, especially given the history of apartheid in South Africa and all of these different the sort of historical context of the word apartheid has a lot of meaning and power, such that it emboldens activism and it emboldens the sort of Palestinian struggle. If it's more than just racial segregation, it's also apartheid. So that is a reason why people often try and cling on to apartheid as much as possible. And that's not me suggesting that this isn't apartheid. That it is not necessarily language that I would reject the conclusion that what's happening in the West Bank is basically apartheid, because I think I've said that before many times, but just that's not what the court is specifically saying. They are, again, probably in order to maintain unanimity, keeping that question open. Because if they'd have said, this violates Article 3, and specifically within the convention, specifically the practice of apartheid, then that probably would start to cause a divergence of opinion among the court.
Yeah.
Whereas they can sort of leave the door open and leave the question open, maintain the unanimity, and just say there's an Article 3 violation there.
Yeah.
So that's what they've essentially done there. And I think that pretty much concludes everything that I've got to say on this ICJ ruling. I could talk about this ruling for months. There's so much, because we haven't talked about the implications that this has on third states. We haven't spoken about the question of self-determination of the Palestinian people, which obviously is a lot broader a question than just the advisory opinion. We haven't talked about what this advisory opinion might say and the impact that this advisory opinion might have on the genocide case. I believe it was Turkey that has that filed an intervention. I believe it was even today or yesterday that makes reference to this. To this advisory opinion, and I think Turkey are the first states to intervene in the genocide case after the advisory opinion has been issued.
Yeah.
And we haven't talked about the implications that this may have towards the Nicaragua judgment, the Germany-Nicaragua case, and even the ICC judgments and the ICC cases that are going through as well. So
I think moving forward, we'll see that this has been used as a springboard for further judgments like that.
hopefully.
Yeah.
I mean, the previous advisory opinion didn't really do anything. The Wall case, that was in 2004. And I guess that causes a lot of people to come to the conclusion that international law isn't the place for solving the Israeli-Palestinian crisis. It might be diplomacy, it might be international politics, it might be, you know, backdoor deals that get a negotiated two-state solution over the line. But that's a question that's more of a geopolitical debate to have rather than necessarily a legal one.
Yeah.
Okay, so I think that's everything. Have you anything you want to say about this groundbreaking case?
I don't think so. I think that I'm pretty happy with everything said.
Yeah.
As far as I'm at liberty to say.
You did well, I think. You did very well. Yeah.
Well, thank you.
International lawyer for the day.
Oh, heck yeah.
Yeah. Like always, make sure you like and subscribe, and if there's any questions that you want to have answered, put them in the comments down below. If there's any suggestions for topics that you want us to talk about, put that in the comments down below. Make sure you click in the link to the Substack article, which will be released. I'll also do a community post releasing the Substack article as well, which goes into all of these things in more detail with more citations and stuff like that.
I would also like to suggest that in the comments, if we're going to be talking about this, to keep it to the substance of what we've said today, because I know there's a lot of kind of ancillary, very heated points that can be made with respect to this conflict, but I don't know if that's fair to put with this podcast episode, if that makes sense.
Well, while I commend your attempts there to try and
stem the flow.
To try and stem the flow of people talking about everything else that isn't this judgment. Good luck seeing that actually happen.
Yeah. Well,
anyway,
we'll see what happens.
Exactly.
We'll have a lot of fun, I think, reading the comments.
Exactly. You're the next person to be doing a podcast episode, so I look forward to that.
Yeah, that'll be in 2 weeks' time. We're gonna do a social history of the criminal trial.
That's gonna be very fun.
Yeah.
So I'll stay tuned for that in a couple of weeks' time.
Yes.